DM. Both parties are present in the virtual courtroom. We're here on the plaintiff, Ms. Clausen's motion to enforce the divorce judgment in this matter. And Ms. Clausen, I've read your motion. Is there anything else you'd like to say at this time?
No, I do have a question though. I don't know if I have to come down or is it possible for you to, I don't know if we have one, put a restraining order in place?
Mine, Ms. Van Miller, isn't there a PPO?
There is a PPO with the petitioner being Mr. Clausen and the respondent being Ms. Clausen.
All right. Yeah, Ms. Clausen, you would need to file your own motion and you can
Okay.
do that at the PPO office.
Okay, thank you.
All right. But anything else you have that's not in front of me today? So anything else you about your motion that you have in front of me today? You're essentially asking for the vehicle in this matter, is that right?
Yeah, I have asked for immediate removal of my name from the Pacifica because he lets other people drive it and I'm still the sole responsible party for that vehicle. And I don't want anything to happen to that vehicle while it's in my name. And the Durango, he put it somewhere so I can't find it and I can't get it. And
okay, so which vehicle is it that you want
the Durango
returned? The Durango, okay.
Yes.
And what year is it?
2016, I believe. 2016, I believe. 2016.
The defendant is awarded that vehicle.
It was the way when I felt the thing.
Hold on a minute. I'm looking at your judgment, and what's in writing is what I have to go by. And it says the defendant is awarded the following personal property free and clear of any claim of the plaintiff. And it lists a home and it lists the Durango.
So I don't get the home and the Durango?
That's what you have in your judgment.
Then it was done backwards because when
all right. Let me just stop you, okay? I have to enforce what's in writing at this point.
Oh my God. They had me do it backwards.
Listen to me, okay? You did this representing yourself. The Legal Assistance Center can only provide you forms. They cannot provide you legal assistance or legal advice. I know they told you that. There are things you can do to fix this. I believe that Mr. Clausen has a motion coming up on January 19th to set aside the default. So there's a bunch of stuff going on in this case and kind of a mess, frankly.
Yes.
And I frankly advise both of you to consult with attorneys because this is going to cost you way more than, sir, hold on.
Go ahead.
Sir, hold on. This is going to cost you way more to untangle this mess than what it would cost to have attorneys straighten this out for you fairly quickly. Okay, but it's up to you.
Yes, excuse me, ma'am. Because when I went to legal assistance and I asked them to show me where I would put what I want and where I would put what I want him to have, that's how they told me to fill it out. They said, go here.
If that's what happened, then yeah. I'm sorry but again, you're representing yourself and it's your responsibility to fill that out properly and read what you're writing. So what I will do, I'll have to deny your motion at this time because that's not what the judgment provides.
Yes, ma'am.
And Mr. Clausen, did you have something you wanted to say?
Yeah, I have an attorney on the case.
Okay, who's the attorney?
Sean Whitehead.
Okay, and has that person filed an appearance in this case? Because I don't see it.
He was supposed to be on today, but there's something going on. So I'll contact him and get on top of it, though.
Judge, he is in our waiting room, but we do not have a formal appearance for him.
Oh, all right. Well,
would you like me to admit?
Yes.
I can't even afford an attorney. Mr. Clausen.
All right, ma'am, hold on. The record should indicate that Sean Whitehead has appeared in our virtual waiting room on behalf of Mr. Clausen. And Mr. Whitehead, we had no idea you were on this case, so I will bring you up to speed on what I have already said. I have denied Ms. Clausen's motion because the judgment of divorce clearly spells out that Mr. Clausen is awarded the property that she is asking to be enforced. But I did encourage both parties to consult with an attorney, and that's when I found out you were representing Mr. Clausen. to straighten out this mess. Ms. Clausen indicates that she was told by the Legal Assistance Center to put things in the wrong spot. In other words, defendant and plaintiff are reversed. I advised her that representing herself, she's responsible for that regardless, because the Legal Assistance Center cannot give her legal advice, and she's still responsible for reading what she submits to the court. But I do see that your client, Mr. Whitehead, has a motion to set aside the default scheduled before me on January 19th. Is that right?
Yes, Your Honor. I thought that's what this was for today. I'm sorry. I
No, this is
so
a motion. This is her motion to enforce the judgment, which I've denied. So I will see you all on the 19th. I've encouraged Ms. Clausen to consult with an attorney. Most of them will provide an initial consultation for free. But as I said, I highly advise you to do that. Proceeding on your own at this point is going
I
to cost you
understand.
more
I've
money.
tried. No one would proceed with less than 45 to 6,500 because it's an LLC involved.
Okay, all
And-
right, ma'am, I can't give you
Yeah.
any further advice on this, other than to strongly urge that you consult with an
Yes,
attorney.
ma'am. Yes,
Well,
ma'am.
we'll see you on January 19th. Both parties are
Thank you.
present in the virtual courtroom along with Mr. Swears representing Ms. Huey. We're here on Mr. Huey's motion for a temporary order and his motion for parenting time. And Mr. Huey, anything else you'd like to say about either of those motions? I have read them.
No, I'm just looking for my fair parenting time. That's it.
Okay. Mr. Swears.
Briefly, Your Honor, we did file, and I apologize for the late response. We weren't served a copy of the second motion until Monday.
I didn't receive it. If you didn't email it to my office, I didn't receive it. I don't see it in my notebook. So.
I'd have to check my paralegal, but it'll take 10 seconds, Your Honor. It's not
Okay.
a complicated response. With regards to the motion regarding parenting time, that was not properly served on our office. It was served on our client. It was not served at an appropriate time or filed timely with the court. So we'd ask that just be dismissed as not properly before the court. And then kind of as regards both motions, if the court is inclined to consider Mr. Hughes' motion, based on the allegations he makes in the motion, he just right now hasn't established permanent or appropriate housing for overnight parenting time. We're still in the early stages of this litigation. We just think that it would be premature to order the overnights at this point. He is receiving regular parenting time. There's a schedule in place. So we would just ask that the court refrain from ordering overnight parenting time until we're able to get essentially just more stability into this process. And then the motion for temporary relief simply asks for custodial changes that it would change the established custodial environment. There's just nothing here to support that change at this time.
All right. Thank you, Mr. Huey.
On all the paperwork, it said I had 14 days to file. It did not say that I had to file an attorney. I went down to the Legal Aid Council, and they helped me with everything. And she lives in her grandmother's basement, so I don't think that fair parenting time is very proper. I work full-time. She does not work. I cannot afford a lawyer, so I didn't have somebody to pay for my lawyer. I'm just looking for my fair parenting time. I start counseling this next month on January 5th. There is more to the case than meets the eye. I left because of the way that she treated my 7-year-old that I have maintained 50-50 custody with. And now I am staying with his mother in their basement. I do have a bed for my son that I bought brand new, and bedding. I bought brand new socks and underwear. I have a basket full of clothes. I have everything that I would need to take care of him. I've been in his life his whole life. So this parenting time is not fair. It's just, it tears both of my kids up. It tears me up, and I'm not looking to seek full custody. I'm just looking for my fair time with him.
Mr. Swears, I'll allow some rebuttal.
Yeah, briefly, Your Honor. Again, we're very early in this process. Mr. Huey has not even filed an answer at this point. I don't think anyone's trying to keep the child away from him. We're just at a point where, again, as he said, he's moved into temporary housing with his ex-girlfriend, her family. It's almost a replacement family unit. I just think it's appropriate that we at least get an answer filed potentially refer this over to front of the court very quickly if they're able to make a recommendation. I don't think that establishing a regular parenting time schedule in the near future is going to be a problem. Again, we're just at a point where we haven't even received an answer in this case. We need a little bit of discovery. The court, I'm sure, is aware from the issues in the ex parte and that Mr. Huey's raised. There are some questions. We just need to go through the regular process here as expediently as possible.
All right, thank you. I am going to deny the motion for temporary order that is filed by Mr. Huey. There is a temporary order in place through the ex parte based on what I've heard today. I've heard nothing regarding how a change in an established custodial environment would benefit this child. So I'm denying it on that basis. However, on the motion for parenting time, I will refer the matter to the front of the court for investigation and recommendation. I'll indicate that the parties are to split that fee for that investigation. And in the meantime, the parenting time as ordered in the ex parte order is to continue unless there's either an order of the court based on the front of the court recommendation or an agreement to the contrary by the parents. Yes, sir.
Would the court like?
Yes, sir.
How is me not seeing my son for 7 days fair for his parenting time? Can I ask? And then
it's not fairness is not the issue. That's not what the sir, I'm not going to argue with you. That is not the legal.
I'm not arguing.
That's not the legal standard. I recognize you're not an attorney, but there are standards that there is a standard that the court has to apply.
Yes.
You simply haven't met that standard in what you've filed with the court. And I am sending it to the front of the court for investigation. And if there hasn't been parenting time in the last 7 days, that is not what's provided by the ex parte order. Mr. Swears, how soon can that start?
My understanding is the ex parte order is being followed by both sides at this time, Your Honor.
No, but I'm sorry, I'm not.
Okay, then you both should be following that schedule. All right, we're adjourned.
Your Honor, with the court,
what about Christmas?
like I prepare the referral or does the court?
The court
Can I have some
does
fair
that.
parenting time for holidays?
Sir, you really need to stop using the word fair because it's not about you.
It is about
that
my
is not
son,
the
though.
standard.
I have
It
two
is.
kids, ma'am.
It is, but fair is not the appropriate word. Is he able to have some Christmas parenting time?
Certainly, Your Honor. If Mr. Huey wants to reach out with me, I'm sure we'll be able to work something out.
He should either get sir, hold on.
Sorry, ma'am.
He should either get time on Christmas or Christmas Eve, one of the two.
Fully understood, Your Honor.
Okay. We're adjourned. Thank you.